Hello everyone, I welcome you all to Manu Law Classes Current Affair Analysis. In this particular video, we will discuss July 27, The Hindu Delhi edition newspaper. In this particular video, we will discuss first about FATF, then we will discuss about birth and death registration bill which has been passed. Then we will discuss about the Forest Conservation Amendment Act and we will discuss about WIP Kerala Employment Generation Act, and then we will discuss about the fiscal deficit from the editorial section and about the SEO and the basic static part related to SEO in our editorial section. So let's begin with the very first news, that is about the FATF. Here basically this is a news in transition. We have already seen this news in our previous analysis that center or the Supreme Court has said that Mishra or the Sanjay Kumar Mishra, he should remove or vacate his office. Supreme Court has directed him to vacate his office by July 11th. But center is urging Supreme Court to let Sanjay Kumar Mishra to continue as Enforcement Directorate Chief till October or till October 50. So here this basically the center is citing that his appointment or his position is important for the FATF or the ongoing evaluation by the FATF. So that's why he should remain in office. What is important for us is FATF, what is FATF and what are the basic aspects related to FATF. So just write down these important points. First of all, what is the full form of FATF? It is Financial Action Task Force. Okay, Financial Action Task Force. It is basically an intergovernmental and policy-making body which basically sets standard related to two important things, that is money laundering and terror financing. So these two things are dealt by Enforcement Directorate at national level in India, but for the international level we have FATF. It is basically an intergovernmental body which sets standards and set policies for these two issues, that is money laundering and terror financing. Talking about the objective of FATF, so it is basically there to establish international standard. It is there to set up the international standard and policies at national and international level to combat these two issues of money laundering and terror financing. Talking about when it was came into scene or when it was formed, so it was basically established in the year of 1989 during the G7 summit in Paris. Okay, FATF was established in 1989 during the G7 summit of Paris, and it was basically at that time its role was regarding the money laundering or all the formulating policies against the money laundering. But in the year of 2001, its mandate was expanded and it also included terror financing. Okay, and talking about where its headquarters is located, so it is located in the Paris, France. Right now there are total number of 39 members who are there in FATF, and it include India, China, Saudi Arabia, United States, Britain, Germany, France and European Union. So these all countries are a member of FATF. Now, India became member in the year of 2010. India became FATF member in 2010. Now, FATF basically has two different kind of list. What are these? First one is the Graylist and second one is the Blacklist. Graylist and Blacklist. So, talking about Graylist or Blacklist, these are two different lists which are released by FATF. So, blacklist are the countries who are also known as non-cooperative country or they are called non-cooperative territories. So its total abbreviation is NCCT. These are included in the blacklist. Now these countries basically do what? They support terror financing. They support terror financing and they are involved in the activities of money laundering. So that's why they are put it in the blacklist. And FATF regularly revisits these lists by adding and deleting few countries from these lists. Okay. Talking about Graylist. So Graylist are the countries who are basically considered as safe haven for supporting terror financing or money laundering. Okay, so here basically in the grey list, these are those countries. For example, suppose some country are actually involved, but some countries know that there are some terror financing activities or money laundering activities in their domain or in their area, but they are not taking action against that. So they are working as safe havens, but those who are actually financing, they are placed in the blacklist and they are NCCT territories or countries. Now, inclusion of this particular grey list, any country, if it is included in this grey list, it serves as a warning for the country, for that particular country, that it will soon enter into the blacklist and it will get blacklisted. There are total 3 countries. For example, what are those? North Korea, Iran, and Myanmar. Also, and these lists are updated. So just see the updated list. This is the earlier version. North Korea and Iran is there. Myanmar is, I guess it is not there. So just check it out. These lists are updated. Some countries are added and deleted on an average basis. So here basically these countries are there in the blacklist. Now, what are the consequences if any country is being in the blacklist? They will not receive any fund. No fund will be given to them by IMF, by World Bank, by Asian Development Bank and by the European Union, because these are the major funding association who give prices or money to the other country for their development purposes or for their other purposes. So that's why if any country is placed in the blacklist of FATF, they will not receive any fund from these banks or these important international corporations, or they also face a number of international economic and financial sanctions. So these are the important points regarding the FATF. Moving further toward our next important news, that is regarding the registration of the birth and record digitalization. So here basically a new step is taken by India to generate digital birth certificate, which will be an all-encompassing document that can be used for admission to educational institution, jobs, passports or Aadhaar, or voter enrollment, registration of marriage and others. So here there will be a complete digitalization of the records, and through this particular amendment, the registration of birth and death amendment bill, which has been tabled in the Lok Sabha, it will basically avoid multiplicity of the document to prove date and place of birth, and there will be complete digitalization. One record will be much more enough to get all these important details. Now there will be a centralized register as the bill proposes. It is an obligation for the state to register the birth and the date of the Center Civil Registration System portal. And here the Registrar General of India will share the information, and all these key details, key information will be there in this particular register, and the maintenance of the database will be done by the Registrar General. Here they will be providing basically all the data to this portal or this centralized register, and it will be helpful for transparent delivery of services and social benefit. And this bill also insert provision for the digital registration and electronic delivery of the certificates of birth and death for the benefit of the people, so that they do not want to, like, they should not go to the physical domain and they should not give bribe or all these things. They will get everything in digitalized format, and this bill will help them to do so. Okay, so this is an important bill which will introduce digitalization of the document. It also proposes to collect Aadhaar number of parents and informants if available for the birth registration, and it will also facilitate registration process for the adoption, orphan, abandoned, surrogate child or the child of the single parent and the unwed mother. These all information will be there in this particular database. Moving further toward our next important article that is coming in from the Forest Conservation Amendment Bill. As we already know, Lok Sabha has passed this particular bill. It was in news quite since a long time. So here basically it has been now passed by Lok Sabha and it will go to Rajya Sabha now. So here basically the Forest Conservation Amendment Bill was passed without any changes with the first version which was introduced on March 29, and this bill was basically to amend the Forest Conservation Act 1980. According to the 1980 legislation or the Forest Conservation Act 1980, Center was empowered to ensure that any forest land diverted for the non-forestry purposes is duly compensated. For example, there was also a fund, that is Campa fund, which was introduced, or compulsory afforestation. For example, this is an area which is having forest or which is having vegetation. This area is rich in mineral resources. For example, I want to establish one industry or something over here, so definitely I will clear these forests. So according to this particular FCA Act, it has been said by the center that if you are clearing any forested area, so you have to bring afforestation in some other area. For example, if I clear 100 trees from here, so I have to plant equal number or more than that in any unforested area so that it can be compensated. Or if I cannot do that, so I have to provide fund which will be equivalent, which will be calculated as per the basis that how much resource is this and how much money it can generate. Okay, so this is about the compensatory afforestation or compensated fund which will be there if any forest land is diverted for the non-forestry purposes. Now this bill extends its remit to land even beyond what is officially classified as forest in state and central government record. For example, any area which is having rich vegetation, it will be also considered as forested area, or we can say non-forested area but vegetated area. So if I clear that also, then also I have to give this money or I have to do the afforestation in some other area. Now the amendment which has been introduced by this particular amendment bill, it said that the practice of cultivation, it basically encouraged the practice of cultivation on the non-forest land which can increase the tree cover over time, and it can act as a carbon sink and aid India's ambition of having net zero carbon emission by 2070. So here basically what the government is saying or what the government want to amend in this bill, that any area or the non-forested area, in that area you can plant the vegetation so that it can act as a carbon sink. What is the meaning of carbon sink? For example, अगर मैं यहाँ पे CO2 generate कर रही हूँ through vehicles, तो मैं यहाँ पे CO2 का contribution बढ़ा रही हूँ, तो यहाँ पे अगर मैं एक ऐसा पेड़ लगा दूं या जितना मैंने यहाँ पे जनरेट किया उतना ही पेड़ अब्सॉर्ब कर लेगा फ्रॉम द फोटोसिंथेसिस प्रोसेस, तो यहाँ पे ये किसकी तरह काम कर रहा है? कार्बन सिंक की तरह. अगर हम सोर्स जनरेट कर रहे हैं तो हमें सिंक भी बनाना चाहिए सो दैट देयर कैन बी अ कंप्लीट सस्टेनेबल डेवलपमेंट. तो यहाँ पे यही बात की गई है कि अगर हम नॉन फॉरेस्टेड एरिया में ट्री कवर्स को इंक्रीज करेंगे तो उससे हमारा जो कार्बन सिंक है वो आपका ज्यादा बनेगा. और इंडिया का जो एम है नेट जीरो अचीव करने का. नेट जीरो का क्या मतलब है? जितना हम प्रोड्यूस करें उतना ही हम सिंक बनाए और उतना ही हम एब्जॉर्ब कर लें, सो दैट देयर शुड बी नो सरप्लस इन द एनवायरमेंट. तो ये इंडिया का एम है कि हमें नेट जीरो कार्बन एमिशन अचीव करना है बाय द ईयर ऑफ 2070. ओके, so it basically seeks, this amendment bill basically seeks to remove the restrictions imposed by the original act in creating infrastructure that would aid national security and create livelihood opportunity for those living on the periphery of the area. So these are the important provision of this particular amendment bill. Now, what are the opposition who are opposing? So basically the objection were raised on various aspects of the bill when it was first introduced, and that's why the joint parliamentary committee was formed to investigate on that, and various representatives from belonging to different groups, they came and they discussed. But though the act which is being introduced or the bill which is there, it has been signed or it has been passed in its original format. So the objection are basically on the amendment diluted the Supreme Court 1996 judgment. Just remember about this important judgment, that is the Govardhanam judgment case. Here basically this judgment extended the protection to the wide tract of the forest even if they are not recorded as forest. And there were also objections to the Act's new name, that is Van Sanrakshan Evan Samavardhan Adhiniyam. So basically it is translating the English version of the forest conservation, but the people who are non-Hindi speaker, they are not recognizing themselves with this particular act. So they are objecting against. So this was an important article. Just go through the nitty-gritty of these articles and just read about the static part of the Forest Conservation Act 1980. Okay. Moving further toward our next important article, that is Center moves bill to nominate 2 Kashmiri migrants to the Assembly. So here basically Ministry of State for the Home, Nityanand Rai, he tabled a bill in the Lok Sabha and he suggested to nominate 2 members from the Kashmiri migrant community who basically migrated when there was militancy at its peak in 1989 to 90, and these members should be having 2 reserved seats or they should be nominated and there in the Legislative Assembly of the Union Territory of the Jammu and Kashmir, and 1 member among these 2 should be a woman. Okay. And along with that, it also proposes to nominate 1 member from the Pakistan occupied Kashmir who was basically displaced in various wars that include 1947 to 48 war, 1965 war and 1971 war which we had with the Pakistan, and this basically caused a lot of displacement of the people, so they should also get some reservation or they should also get nomination in the assembly. So this is an important bill. Moving further toward our next important article that is coming in from the state section, and here basically what is important for us is this term whip. Okay. So the Delhi Services Bill, 4 opposition parties issue whip to member. Congress, TMC, RJD, BRS asked their legislator to be present in house today or tomorrow. So here the static aspect of what is whip, who are whip and their historical underpinning, these things are important. So we will discuss in detail about the whip. So our topic is whip. Whip is basically an official of a political party whose main task or whose is to ensure party discipline. Whose task is to ensure party discipline in the legislature, whether it's in state or center. Every party or every political party has their own whip. So the whip ensures that the member of the political party vote according to the party or as per the direction of the party. Okay, vote according to the party or vote as per the direction given by the parties, rather than their own individual ideologies or their donors. Anything else is not considered. They have to vote according to the party. That's why whips are basically, whip work is basically to ensure this particular thing. Now, every political party, whether ruling or opposition, they has their own whip in the parliament or the legislative assembly, and he is appointed by the political party and he serves as an assistant floor leader. Okay, assistant floor leader. Under the 10th schedule, which deals with 10th schedule, which deals with basically the anti-defection law. So this, under this particular schedule, a political party has the constitutional right to issue a whip to the legislature. And there is also one important judgment, that is Kyoto Holohan versus Zachilu case. Just write down this important judgment. It was held in 1992. Under this judgment, Supreme Court held that the application of the 10th schedule is limited to vote on a motion of confidence or no confidence motion in the government, or where the motion under consideration relates to a matter which was integral policy and program of the political party. While the paragraph 21b of this important judgment deals with, it basically provides for a lawmaker disqualification if he abstains from voting as per the direction of the party, then he can be disqualified. Okay, so this is important judgment, and it basically told us about whip power and whip judgment, or whip, how he can, his power to issue, maintain this particular dignity, and acting as a floor leader is important. Now, talking about the historical background, so we know in India, this concept of whip was inherited from the British or the colonial time period. From the British rule, we took this particular office, and the office of whip is neither mentioned in the Constitution of India, nor it is in the rules of house, nor it is there in any parliamentary statute. So this particular office is basically based on the conventions. They are based on the conventions of the parliamentary government. Now, a legislature, if he does not work according to the whip, so he can be disqualified, and this thing or the disqualification is basically decided by the chairperson of the house, for example, speaker in case of Lok Sabha and chairman in case of Rajya Sabha. So this is an important static aspect which you should know from this particular news article. Moving further toward our next important article, that is coming in from the state of Kerala, and here basically Kerala government will roll out employment guarantee scheme for the expatriate. So here basically Kerala government will be the first of, it will introduce the first of its kind scheme in the country for those who are returning, and the scheme is titled as NORCA, or the Non-Resident Keralite Affair Assisted and Mobilized Employment Act. Or here in this particular program, it is exclusively mentioned that it is for the overseas returnees. Okay, so just remember this act, and Kerala is the first state to do that. So in this particular scheme, there will be basically guarantee of the employment for all those who are basically returning from overseas, and here they will be given employment in certain sector where they have expertise, and the state government would basically provide a certain percent of wage of the employee for a certain period of time as per the part of the scheme. And there will be also a registration portal where they can register, and then they can get the money, and there they can register themselves for the employment. So this is an important scheme. Moving further toward our next important article, that is with regard to the economics, and here basically the author is talking about the fiscal deficit and the public debt, which is basically a matter of concern for the long time in India. So here the author is saying that we have a lot of debt to GDP ratio. In this, we have a lot of debt. So here few important terms are given, and you should know about what are these. So what is fiscal deficit? Fiscal deficit is basically total expenditure minus total revenue. Total revenue or total expenditure, it has two components, like first one is from the revenue and second one is from the capital. So these two equate, or these two combine to form the fiscal deficit, and here the total expenditure is subtracted from the total revenue which the country receives. Now there is important term, that is primary deficit. So here primary deficit means fiscal deficit in the year excluding the past legacy of the interest payment. For example, if I borrow something, we take loan or we take something from any IMF or from ADB, from anywhere. So here basically we have to pay interest on that. So when we, from the fiscal deficit, when we remove the interest payment, so we get the primary deficit. And here basically the author is saying that primary deficit in case of India is usually good because we are negating or we are removing the interest part, which is the biggest burden on Indian government. Now, there is an article, or there is basically a distortion which is caused by the financial repression to keep the interest rate on the government borrowing low to reduce the cost. The statutory liquidity ratio stipulated by the RBI, what is SLR? SLR is statutory liquidity ratio. For example, all the banks who are there in India, they have to keep their 18% reserve or their 18% of their demand in time liability in terms of the government security with themselves. So, in order to ensure that they should not get bankrupt, bank should not go bankrupt. So that's why they should maintain a reserve for that. Now there are some other term also, CRR, it is fixed till 4.5% now. So they have to keep some money or some money in cash with themselves with the RBI. With the RBI, all the banks have to keep 4.5% of their reserve in form of cash with the RBI in order to ensure if there is any unforeseen condition, so they can go to this reserve. So basically these things add up to the debt market in India, and here these things basically add up to this problem. Now this was the crux of this whole article. If you want to read it in detail, you can read it, but these few important points are important from your examination point of view. Moving further toward next article, that is regarding SCO. So here the article is basically analytical in nature, which is not important from your examination point of view. You should focus just on facts. For example, the 23rd meeting of the councils of head of the SCO was held in India. So you should know that who is chairing this 23rd meeting, that is important. And the Iran, it became the full membership, it gained the full membership, and soon Belarus will also get the membership. So in this article, the author is just saying that how SCO is working, how its working is good, and it is working toward a multilateral or multipolar world, and how our relationship in SCO is based on mutual trust for common security. So these things or this analysis is there in this article. If you want to read it, read it. But the static part or the factual part, which is important from your examination point of view, we will cover over here. So SCO, or the Shanghai Cooperation Organization, it is basically an intergovernmental organization founded in Shanghai, China on 15 June 2021. And who were the founding members? Just note it down. It was founded by the leaders of China, Kazakhstan, then comes Kyrgyzstan, Russia, Tajikistan, and Uzbekistan. Okay? So, SCO has been founded by the leader of these countries. Okay? Now, apart from Uzbekistan, the other 5 countries was already a part of Shanghai 5. Apart from Uzbekistan, these all countries, that is China, Kazakhstan, Kyrgyzstan, Russia and Tajikistan, they are member of Shanghai 5, which was basically constituted in the year of 1996 by China to address the border security issues with all these 4 neighboring countries. The cooperation was renamed SCO after Uzbekistan joined it in the year of 2001. Okay, so it was formed in the year of 2001 and it was renamed, Shanghai 5 was renamed as SCO or Shanghai Cooperation Organization. Currently, it has 9 members with the addition of Iran, newest member, and soon Belarus will also join it. So with the addition of this, it will become 10, but now it is having 9 members, which include China, India, Kazakhstan, Kyrgyzstan, Russia, Pakistan, Tajikistan, Uzbekistan, and Pakistan. Okay, so these are the 10 members or the 9 members, and apart from that, Iran is also a part of it. Okay, India and Pakistan, they joined SCO in the year of 2000 70. Now, SCO Secretariat is located in Beijing. Just remember this point. And there are two important mechanisms through which the SCO work. It has two permanent bodies. First one is the Secretariat and the second one is the RATS. RATS is what? Regional Anti-Terrorist Structure. It is based in Tashkent. And it is the executive committee of RATS is the second permanent body of this particular organization. RATS basically serve to promote the cooperation of the member state against terrorism, separatism and extremism. Official language of SCO is Chinese and Russian. Okay, just remember these important keywords which is important from your examination point of view. Moving further toward our next important article, that is from the text and context section, and here basically a term you should know that how the economic geography is affecting Delhi NCR. So here the author is saying that the engines of the India's growth are the economies of the mega city region. For example, if we see the NCR region, it is contributing a lot or it has a highest concentration of job and people in the country, and it has generated a GDP of $370 billion in 2015. But the challenges is with regard to the infrastructure cost, increasing land and infrastructure cost, growing income inequality, poor air quality, land and water pollution, lack of natural resource and institutional coordination barriers. So these are the important drawback with regard to the growth and development. Now, the recent report which has been released, that is Morphology of Delhi National Capital Region's Economic Geography and its Implication for Planning. It is basically a study which is conducted regarding the evolution of jobs in Delhi NCR from liberalization till now, till 2013 and 14. It says that the core and the periphery, for example, Delhi is the core and periphery is like Ghaziabad or it's like the NCR region. So the core periphery spatial system is in transition and it is growing. This periphery is growing. Core is already overcrowded and the periphery is now also getting overcrowded. So this is basically the important point of this particular article. Now in Delhi NCR as elsewhere, there is a spatio-economic assessment which can help the target infrastructure investment and foreign direct investment to economically dynamic location to ensure better return and job growth. So these are the important points. That's it. Moving further toward our next important article, that is coming in from the news section, and here basically the important news is that 530 districts were reported as free of manual scavenging. This is very important. Jammu Kashmir, which are these five cities or states: Jammu and Kashmir, Manipur, Telangana, Andhra Pradesh, West Bengal and Jharkhand. They are the state and union territory that have the highest number of districts yet to declare themselves free of manual scavenging. Now, as said by the Social Justice Ministry. Manual scavenging is basically what? It is cleaning of the sewers by humans, and that has been banned by the Supreme Court because it is very risky in nature, and that's why it is not done and it has been banned by Supreme Court. Now the ministry said that 530 districts had so far been reported themselves to be free of the manual scavenging they have removed, and 100% of the district of states such as Bihar, Rajasthan, Tamil Nadu, they have declared themselves 100% free of the manual scavenging. So this is an important data. Just get through it, just read out or note out all these important points. Moving further toward our next important article, that is coming in from the international relation. Here basically Taiwan holds its first army drill at airport. Taiwan staged its first ever military drill at Taoyuan International Airport, and it basically halted the commercial traffic as the soldiers practiced defending the facility against the simulated attack by China or Beijing. So these were the important articles which we discussed in our today's analysis. We will do this discussion on a daily basis. Just be regular, be religious, and be honest with your studies. Thank you everyone. Thank you for attending this lecture.